Good evening. I'm Attorney Lawrence Berliner. Thank you all for coming to tonight's webinar, Finding Your Voice as a Parent webinar, our continuing series. Here with our co-host, Jane Faherty, Director of the JumpStart program, and our valued guest, who's returning from our last webinar to continue some of the questions and issues that we ran out of time this past October, Allie Grafman, who's an advocate in the field of special education. I was going back, Jane, we're now starting our fourth year. I think we started November 2020, so now we're starting our fourth year. We want to thank everybody who continues to participate in our webinars. We appreciate your feedback, questions. So tonight, it'll be the three of us, Allie, Jane, and myself. We have many questions that were given to us prior to tonight's meeting. If there is a question that you want to ask, we would ask that you put it in the Q&A section at the bottom of the computer rather than the chat section on the right side of the computer screen. This is a webinar that's being recorded. What's in the chat is recorded, what's in Q&A is not. So without further ado, I have a brief disclaimer. As I mentioned before, this webinar is being recorded. A copy of the webinar will be provided to each person who is registered. So we always have questions. Can we get a copy of tonight's presentation? The answer is yes. I believe that's in a YouTube. Okay. The information provided during the webinar does not constitute specific legal advice regarding your child or your child's circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship with Attorney Lawrence Berliner or myself, or a professional relationship with Jane Faherty or Allie Grafman, the Stamford Jewish Community Center. By signing up, you agree to receive information about future webinars and events from the Stamford Jewish Community Center, the Law Office of Lawrence Berliner, LLC. Zoom is a third-party provider and not an agent or associated with the Law Office of Lawrence Berliner, LLC, the Stamford Jewish Community Center, Jane Faherty, or Allie Grafman. The information we provide is based upon Connecticut law. All of us are focused, our practices in Connecticut using Connecticut law policies and federal law. We very much appreciate those who attend our webinars from other states and in some cases other countries. However, the scope of our practice as advocates and attorneys is based here in Connecticut. So there may be local variations on the law, and you should consult your local jurisdiction for policies and laws that affect you or your child. Let's see. We are Jane and I, and since Allie is a regular guest, I'll add her as well. We're part of a community of concerned parents and professionals who are still learning how to connect with one another. This all started in the midst of the COVID-19 pandemic. And here we are supposedly post-pandemic, but we're still continuing to learn and learn from one another. We've been moderating a series of webinars to address these still unprecedented times. The need to address social, emotional, educational impact upon our children's educational journey could not be greater. And we're here to try to empower parents and others who work with children for the road ahead. Tonight, we're discussing many questions that we received prior to tonight's webinar. Allie Grafman will participate. She's an advocate with ABC Advocacy, LLC. She'll do her own brief introduction. Jane is also an advocate and wears many hats, including being the director of the JumpStart program, and she'll describe that. We have several topics, but we're going to lead off with myself discussing the independent evaluation. We'll be discussing a lot of the struggles with academics and behavioral issues at school, navigating next steps, and then, of course, what I think we enjoy the most is trying to answer the questions that have been presented. But just like with every other webinar, we often have so many questions and too little time. So we'll do our best to get to everybody. So Jane, what's new? How have you been since we were here last?
Hi, Lawrence. It's lovely to be back again tonight. As you said, it'll be 4 years in March that we've been doing these online webinars. That's one of the positive things that came out of COVID is that we can now connect and meet lots of people in different ways. I just want to acknowledge that whilst this for a lot of families isn't a very exciting time of the year, it can also be extremely stressful when you have children that require more support. And so I do appreciate people taking the time to come along this evening. And it's also a difficult time of year for parents because it's when you get progress reports or you're at the start of a new academic quarter for your student, for the student. So whilst this is supposed to be very exciting and joyful for a lot of families, it can be an extremely stressful time of year. So it's great to be here tonight to hopefully alleviate some of the concerns that many of the families have. Some of which are going to be about IEEs, and Allie is also here to answer a plethora of other questions. And as Lawrence said, please address anything in the Q&A. I do have my own business as an advocate, but I'm also the executive director of a program called JumpStart, which is a program for toddlers with developmental disabilities and delays located at the Stamford JCC and also at the Maritime Odyssey preschool in Norwalk, where the children receive one-to-one instruction, and we partner up very much with birth to 3 organizations, and then I help transition those students into the public school throughout Fairfield. So it's lovely to have you back with us again tonight, Allie, to share the numerous questions that we received prior to this webinar. We apologize in advance in case we do not get to answer all of them, as there were rather a lot, and we hope to answer the ones that come in tonight as well.
Allie, you're next.
Okay, everybody, welcome back if you have been participating before. And if you have been, you probably are familiar with who I am, but I will give you a brief background of my experience. Basically, I've been in special education all my adult life. I began after graduation from college as a special education teacher. I've been in a classroom from pre-K all the way through high school. In various positions. And then I became an administrator in special education and became a coordinator and a interim director in a public school. So I have been navigating the whole avenue of special ed and really do appreciate parents' perspective. As Jane said, this is a very stressful time. Q1 grades are around this time of year. I'm getting tons of emails from parents. Oh my gosh, my son, my daughter, you know, the grades. The honeymoon is over for many of our students, and now we're beginning the nitty-gritty of the curriculum. So it's a perfect time to have this webinar to alleviate, hopefully, many of your concerns, and we will continue to strive for that. So again, thank you for all your contributions with the questions, and I hope that each and every one of you gained some benefit from this webinar. Thank you.
So when we go to PPT meetings, that's what we call them in Connecticut. There's CSE meetings in New York, IEP meetings in other states. School districts are supposed to provide a copy of what are called the procedural safeguards. And these are your child's rights. These are your rights as a parent. These are procedural rights that are substantive and enforceable. All of the rights are important. Tonight, we're going to focus on one of those procedural rights, and that is the right for a parent to request a publicly funded independent evaluation. And in a moment, I'll have a couple of slides. I think it's 5 or 6 slides, and we'll go over, the slides will be available, and going over the independent evaluation. So the whole process of, one moment, what?
We have a lovely expert that helps us with our technical pieces on
Yes.
this webinar. It's actually Lawrence's daughter, Rachel, so she might be giving Lawrence some support at this moment.
Okay, so bear with me as here we are. Okay, the right to an independent evaluation is probably one of the most important rights that parents have to contest information coming from the school district. And typically, a right to an independent evaluation starts with a school district completing an evaluation. And what do I need to do? Okay. The school district completes an evaluation. It could be an initial evaluation, a triennial evaluation. Triennial are the evaluations that are done every 3 years. And the school district evaluations are supposed to consist of a variety of tools, functional, developmental, academic information on determining whether or not a child is a, quote, child with a disability. The child with this disability is the legal definition. In Connecticut, we have 14 categories of eligibility. I think there are 13 in the federal law. We have 14. And based upon the results of the evaluation, that will determine whether or not a child is eligible for special education. That will determine the content, scope, direction of the IEP, the individual education plan. And the evaluation is supposed to be sufficiently comprehensive to evaluate all area of the child's actual or suspected disability. And if they are a child with a disability, then we get into the development of an IEP. Now, parents have a right to disagree with the school district's evaluation because in my experience, which is by no means is universal, sometimes school districts under-evaluate a child. Sometimes they find a child has no issues affecting their education, and the parents disagree with that. So when a parent disagrees with an evaluation from a school district, they can either obtain a private evaluation by paying for it themselves. Sometimes insurance will cover it, most of the time it will not, and parents will decide whether or not they want to obtain a psychological evaluation, occupational, physical therapy, speech and language, audiological, whatever evaluation they feel is necessary. So what ends up happening when the parent disagrees, they also have a second option, and that is to request the publicly funded independent evaluation. And we're going to go to the next slide. Our State Department of Education has a booklet. It was released in March of 2018. That's called the Guidelines Regarding Independent Evaluations at Public Expense and in School Observations. I'm only going to focus on the first part of the guidelines, which are the independent evaluation. Parents need to state, preferably in writing, their disagreement with an independent evaluation. They can do that at a PPT meeting, or they can do it after a PPT meeting, whenever they disagree with the evaluation. And the school district has to provide the parents with a copy of their policy on independent evaluations. And when you're seeing these references to OSEP, letter to PETSCA, and you'll see a few others, the U.S. Department of Education, Office of Special Education Programs, OSEP, has issued a series of policy guidance letters on independent evaluations. So, letter to PETSCA requires the school district to provide parents with their criteria for an independent evaluation. Do you have to have a PhD? You have to be licensed. Sometimes there are geographic restrictions. And their policy on when, how, and whether they'll grant an independent evaluation. The school district has two choices when they receive a parent's request for an independent evaluation. They can either agree to the private evaluation, and provided the evaluator meets the criteria for outside evaluations, or they can deny the independent evaluation request, file for a due process hearing against the parents in order to defend their evaluations. Now, the timing of the filing for a request for a due process hearing is not specified in the federal law. The phrase "without undue delay" is the standard. So without a specific timeline, 14 days, 45 days, whatever, it was up to the courts and the hearing officers to decide what is reasonable, what is a reasonable delay, what's an unreasonable delay. So generally speaking, the school district should file for a due process hearing within 3 to 4 weeks after the receipt of a parent's request for an independent evaluation. At the due process hearing, the school district has a burden of proof to demonstrate that their evaluation followed federal law and professional standards. At the due process hearing, the parents have a burden of proof to show that the school district's evaluation did not follow federal law or professional standards. So sometimes you end up with literally a battle of the experts. And I was involved with a case a few years ago, Greenwich Board of Education versus student, a State Department of Education final decision from 2019, where we had a private psychologist versus the school psychologist, the battle of the experts. And the question was, with what the school had completed was an evaluation. The school district stated it was a, quote, screening, which is defined in federal law. And our experts said, no, it was an incomplete evaluation. Fortunately, the hearing officer agreed with us and ordered the school district to pay for the independent evaluation, meaning the school district lost. There are some of the procedural rights or OSEP letters out there that parents are entitled to one independent evaluation per year. And what that means is if it's a psychological evaluation, you can't ask for a second one, but if you disagree with the audiological, the occupational therapy, you can still request an independent evaluation. You're not stuck with one total evaluation per year. Some school districts advise parents of that. Parents are entitled to an independent evaluation if a school district did an incomplete evaluation. And that's what the OSEP letter to boss talks about. So if the school district should have evaluated, say, 5 areas and only 3 were covered, then the parents can get an independent evaluation because the school district failed to get the complete evaluation in all areas that needed to be assessed. The school district doesn't get a second bite of the apple if the parents request an independent evaluation. The school districts are not permitted to say, oh, give us another chance, we'll fix whatever deficits are in our evaluations. And that's what OSEP's letter to Carol talks about. There are, as I mentioned before, there are criteria for independent evaluations. What kind of professional qualifications, licensure, in some cases, geographic limitations, like you have to be licensed in Connecticut. Some school districts require that. The school district needs, on a case-by-case basis, to consider exceptions to the rule. And again, that's what letter to Petska talks about. In other words, a school district cannot simply say, sorry, that person is licensed in New York and not Connecticut, and we're not going to consider it. If there's a compelling reason, then they should accept that on a case-by-case basis. And the same thing comes into play with cost of independent evaluations. The school district can have reasonable caps on the cost of an independent evaluation. However, they have to consider on a case-by-case basis exceptions. I had a case a few years ago where the school district had a cost cap for a neuropsychological evaluation at $2,500. I don't know any neuropsychologist in Connecticut or anywhere up and down the East Coast that would do a neuropsychological evaluation for $2,500. $4,500, $5,500, $8,500, they're all, but $2,500, no. So I had filed a complaint with the State Department of Education saying this violated letter to Petska, my client's rights. And rather than investigate the complaint, the State Department of Education urged that district to grant an exception on a case-by-case basis. So we were able to get our independent evaluation that costs more than $2,500. Let's see. I think we're okay. I think that's it on the independent evaluation. So these are rights that are very important. I might point out that the State Department of Education's website is ct.gov. That access the departments and agencies, and the alphabet will open up, and you want to click on the letter E for education, open up that. Let's see, there's a special education icon, and within the special education icon, there's a list of publications, including many publications, including the one I've referred to. Now, one of the, actually, we just got a question. Do we disagree with the results or the recommendations? You just have to disagree with the report. You're not required. The school district can ask why you disagree, but they can't compel. All you have to say is, I disagree with the report. I'm requesting an independent evaluation. So if it's the results or the recommendations, I think those are the opposite sides of the same coin.
So Lawrence, one of the questions was that if you disagree with the school and the school says, okay, here's a list of people you can go to that are private providers, how independent is that list that you might be provided by a district?
Excellent question, whoever asked that. School districts can suggest, but not compel, that you select an evaluator off their list. Many times many times the parents don't know where to go for a private evaluation. So the school district can suggest private evaluators. There's one school district that I deal with that has a, quote, list of vendors. Those are the vendors on their list. And several of the vendors are people or professionals that I make referrals to. So I said, pick one of those. They're already vetted. They'll get paid. You don't have to argue. And then there are other school districts that don't have an acceptable list of vendors or private evaluators. I was speaking to a parent last week who requested an independent evaluator. And the school gave her the list. The parent didn't know she could go off the list. And I asked, what was the name of the evaluator? And the parent gave me that name. And I said, I'm sorry you didn't contact me before selecting the evaluator. The evaluation has been complete. We're just waiting for the report. And she asked, do you have any concerns with that evaluator? And I said, well, I don't know what that evaluator is going to recommend, but my experience with that psychological practice is they tend to be more supportive of school districts than parents. So even though they're private and even though they're independent, for lack of a better word, there's a bias with a small b bias with that. So I try to find evaluators that are not focused on the school, not focused on the parents, but focused on the students' needs. And that way we get truly an objective viewpoint. Somebody asked, does this apply to New York as well? The independent evaluation is all 50 states and the territories. It's a federal law, the right to an independent evaluation.
One more question on the IEEs that we had before the webinar was, what records do the school and should the school turn over with the final completed IEE report?
Well, the school district doesn't complete the independent evaluation report. The school district completed the initial evaluation or the triennial or updated. So the parent should have a copy of that report. In order to disagree, you have to have the report. And if they disagree, request the independent evaluation. The documents that the school district has to turn over are their criteria for independent evaluations, the policy on independent evaluations, and ultimately their decision, are we granting or denying the request? So as far as the documentation, it's more about, you have the report and you just want to have the policies and procedures for independent evaluations and the criteria for the outside evaluation.
In my experience, whoever the evaluator is will ask the school district what information the evaluator needs. So, I mean, many evaluators want the basics, like the school's psychological report, the academic report, and so forth. But there may be special circumstances that whoever is doing the IEE, administrating it, will ask for specific information from the student's file. So it's usually not the parent's burden, but certainly if a parent would like to share something in the file that may or may not be requested, then certainly ask the school to send that. And one more thing, what I do as an advocate is I encourage all my parents and guardians to ask specific questions that you would like answered for the IEE, whatever specific evaluation is going to be done. You as a parent know your child the best. So what information do you want to glean from this evaluation, and get those questions in writing to the evaluator. I usually ask my parents to share it with the district as well, but the evaluator needs to have your input, because that's the most important.
Right. And I just want to add to that, Allie, and just say that, if we have the school district contributing questions or, then there's a buy-in. So it's not an us versus them, it's an report. We all have a vested interest in the outcome of the report. But again, it's a private evaluation paid for by the school district. So the parents are in the driver's seat. If the school wants to contribute, fine. If they don't want to contribute, that's fine. But I think it's a good idea if we're all, in effect, looking to the outside evaluation as a tiebreaker. The parents say yes, the school says no, and now we have a third objective opinion. And if that's going to be the tiebreaker, it'd be very nice that everybody's buying into the results.
So I've worked with families that are successful, they have the IEE, they have the report, but then they don't know what to do with that information. And one of the questions we received ahead of time was, how can parents know the level of need for their children and advocate for it? So even once you have these evaluations, it can be hard to know what it is you should advocate for, because you don't necessarily know what might be available to support your child within a district and what your legal rights are to have them supported in various ways. So my recommendation for that is that contact advocates such as Allie or attorneys such as Lawrence or myself, or speak to other parents within the district, because you might not be aware of some of the related services that your child might need and be allowed access to and have access to. So even when you have an evaluation or you have information regarding your child, it is worth consulting somebody to find out how to best use that information to give your child the right IEP and related services, and indeed to review and revise maybe existing goals and objectives with that information, because it can be overwhelming. Yes, you have the report, but what then do you do with that report to have meaningful impact, to help your child make meaningful progress?
Just want to piggyback on that a little bit, Jane. It's important for families to know that it's not what the school district has available. It's what your child needs. What is the requirement for your child? what is the child entitled to. So often I experience, the district will say, oh, well, we don't have a reading program like that that's recommended maybe in the IEE, or we don't have a reading specialist like that. Well, if the recommendation of the IEE is a specific program or a specific model of instruction, and it is evidenced in the report, that's what you adhere to. And the response from the district saying, well, we don't have that is really not acceptable. So you have now with an IEE a recommendation, and that's what you you request, and certainly be adamant about it, because it's evidenced in the report that that's what your child is required to have.
Excellent point. We have another question that came in this evening, and I should neglected to mention that the procedural safeguards are available for the Birth to 3 program. And it's a different program. It's not a school district. These are, I think it's through the Office of Early Childhood Education. That's the state agency, and they have local contractors for the Birth to 3 program. But the IEE request also applies to the Birth to 3 program, that if you disagree with the Birth to 3 provider's evaluation, you have the same procedural right to request a publicly funded independent evaluation, and the due process hearing and cost caps, all the others should apply with equal force, whether your child has an IFSP, an individual family support plan, or an IEP, an individual education plan. So whoever gave us that question, it's a good point. And often I myself, I don't know about Allie or Jane, I don't get that many Birth to 3 program referrals, because often by the time a family will contact me, they're within that 6-month transition period. 6 months before turning age 3, we start the process of transitioning from Birth to 3 to special education. So sometimes parents will wait until the actual transition occurs and pick up the questions, the fight down the road. But if your child is in the Birth to 3 program, you disagree with the evaluations, by all means, you can ask for an independent evaluation before the transition to special education.
So once you've got all the information, you've got some data, you've got IEE results and other tests and so on. We had a question saying, can parents rewrite IEP goals and objectives if they want to change them? Well, the answer is you are part of a PPT team. So IEP goals and objectives should be agreed upon within that PPT team, but you as a parent certainly have a lot of insight and information to determine the priority of some of the goals, particularly if they're related to independent living and some of those pieces within the home or community environment, behaviors that you see that might not be happening, or the school might claim that they don't see, but it's hard for you to imagine happening at home repetitively. Why are they not happening in the district? So any other thoughts on that, Allie and Lawrence as well?
Yes, I do. I absolutely agree with you, Jane, that as a parent or guardian, you are definitely part of the PPT. But let's just take a step back. To prepare for the PPT, it's really important that you ask the district to send you the proposed goals and objectives prior to the PPT. It's very, very important that you get to see those goals and objectives before they present them, because that way you have planning time, you can dissect the goals and objectives, and you can certainly become a much more engaged and active member at the PPT, having that preparation time. Now, there are situations given at a PPT when the school they say to you, well, we can't give you goals and objectives because we don't know if your child is going to be eligible, which is a PPT decision, and that decision isn't made until that PPT. So in which case, let's just say you're at a PPT and it's either a triennial or an initial PPT, and your child is deemed eligible for special education, then I would say as an advocate, you listen to the goals and objectives that they're proposing, but you would say to them, I would like to use and you have time for that IEP to be finalized. You have 5 school days and to make any revisions that you would like. So you would ask for the draft goals and objectives before the IEP is finalized. And that way you can certainly provide any revisions that you would like to see. So, being prepared is definitely very, very important, but also make sure that when the team presents goals and objectives, you have the opportunity to give your input, whether it is after the PPT, using your time before the IEP is finalized, or it's during the PPT. But you as a parent need to give your input and your feedback.
And to add to that, the federal regulations are very, very clear that the school district, the members of the PPT, need to consider the parents' input and concerns for enhancing their child's education. In other words, parents are not just a guest at the PPT meeting table. They are active members, equal members, and their input, especially when they see their child in multiple settings. School districts generally see a student in one setting, the school. Parents will see their child at home, in the community, at school, in any other setting. And parents are a very valuable source of information. I've had many, many parents in my career say, what could I possibly know? I'm not my child's teacher. And I said, well, actually you are. They said, I am? Who taught your child how to speak or to walk or to hold a fork or to play nice with the, at the playground, or all the other things that parents are called upon when it comes to raising their child? And that doesn't end when they go to school. If anything, especially with a child who has an IEP, the parents have to be very actively engaged in ensuring that their child's needs have been addressed, that we're seeing meaningful educational progress. As was mentioned before, it's not what's available, it's what the child needs. The IEP is based upon the child's unique needs, not what's available. So it's very, very important that parents be active members of the PPT. Now, sometimes parents don't know what to ask for, and that's a legitimate concern. I will assume, without knowing, that all children have pediatricians and other professionals in their lives. Those are important sources of information. Parent intuition and instinct, if it doesn't feel right, it probably isn't. Looking at homework or work samples, does this look like a third grader or not, or whatever the grade is. How your child, other subjective matter issues like diet, eating patterns, sleeping patterns, somatic complaints. Child doesn't want to go to school in the morning, constantly tardy or not going to school at all. Or they're coming home from school with major meltdowns. Well, the schools will say, we didn't see anything happen, so the meltdown occurred because something happened on the bus home. Of course, it's something that happened, because often the child is holding it together during the school day and unloads when they come home. So it's parents who know their child, know their behavior, see that things are not adding up or not making sense. Go with those instincts, go with that knowledge.
The other thing too is the devil is in the detail. Even if you're relieved that a goal and objective is in there that you think is appropriate, look at the detail of that goal. I was at a meeting last week And the goal was for handwriting and for a child to write their name and to spell their name correctly. And that would be considered mastered if they did it with 80% accuracy. If you have a long name, maybe 80% may or may not be reasonable. When you only have 4 letters in your name, to have 80% accuracy would not be an appropriate goal. So the devil is in the detail, and just make sure that you pay attention to that. And the expectation is a high expectation for your child, just as it would be for any other child. So just pay attention to that. You might be relieved the goal and the objective is in there, but how is it written? How is it going to be monitored? Who is going to be doing monitoring? What's the frequency of that as well? So pay attention to that information.
That's an excellent point, Jane. Oftentimes, objectives under the goal are written with they should have criteria for progress monitoring to measure progress. Oftentimes what I see is the goal or the objectives has to be achieved in 4 out of 5 opportunities, let's say. Well, as a parent, you may, you're not expected to know this, but think about what 4 or 5 opportunities is given one entire IEP year. Okay, that the IEP is for 1 year, it's annual, okay? 4 or 5 opportunities means that your child only has to demonstrate that skill 4 times out of the IEP year. When I see that, I say, okay, let's step back. We need to look at that criteria very, very carefully, because many kids can achieve 4 opportunities in an IEP year, but can they achieve them consecutively? Can they achieve them consistently? What is the frequency? So you really have to look at those objectives with a fine-tooth comb and really understand how they are written and what the expectations are. And it is a challenging task, it really is. But I think with experience, I think we become more and more adept at it.
And I would just add one thing to Allie's comments. It's the generalization of skills, because if a child has supposedly learned something at school, they should be able to generalize it to home and other settings. So that there are many ways to measure progress. Progress monitoring is not just what happens in school, but the carryover from school. And so that's important. We had a couple of questions that came in, and I'm going to, at the risk of repeating myself, we always advise parents, if you don't agree with the outcome of the PPT meeting, make sure you send an email or a letter saying, I don't agree with the IEP, or my comments aren't reflected in the record of the PPT meeting. So if you receive an IEP that you don't agree with, you need to let the school know. The school is obligated to read and listen. They're not required to be clairvoyant and read your mind. And for me, I'm old fashioned. I do things in writing. I want to see a written record. I never doubt my clients when they say they had a meeting or they had a telephone conversation, but there's no record of the meeting. When you send an email, note, or letter, that's your written record.
And parents are also able to record PPT. So you need to let the district know prior to the meeting, but you are able to record it, which is also documentation of what went on in the PPT.
Yeah, just let people know if you're watching from a different state. In Connecticut, you need to let somebody know in advance that you're recording them. Both parties need to be in agreement with that. In the state of New York, you don't need to disclose that you're recording. So there are different state laws regarding recording conversations too. So again, remember, this is regarding Connecticut particularly.
We had a question that came in tonight about a parent who suspects that the school district's report has been, quote, sanitized. Is that a justification for an independent evaluator? The answer is it depends. And often when I have that suspicion, there are evaluators that I work with on a regular basis, and I might ask them to take a look at this report. Does this add up? are the recommendations supported by the clinical findings. And often with school district evaluations, there are very few recommendations. The most common one is the recommendations will be discussed at the PPT meeting. That doesn't help me, it doesn't help my clients. So if you have a suspicion that the report may have been, quote, sanitized, see if you can speak to a psychologist, pediatrician, audiologist, occupational therapist, physical therapist, whatever professional discipline is involved, and take a look at the school's report and see if it adds up.
We had a question ahead of time saying, and this doesn't necessarily pertain to a stroller, it could relate to other adaptive pieces of equipment that's necessary. What are my options for strollers as my child outgrows standard sized strollers, I'm assuming within the school environment? Allie?
I was going to say, when I saw that, I wasn't clear. And then when you add in the school environment, if the stroller is needed to access the school setting, then it's part of that IEP. It's adaptive equipment. So I have had situations where we ask, have an assistive technology evaluation as one possibility, an occupational therapy evaluation, a physical therapy evaluation, because what we're looking at is the student's ability to access the building, what's going on in the building physically as well as programmatically. So if it's the stroller is now too small because the child has grown, ask the school district to do an evaluation, assistive technology, physical therapy, occupation, whoever does the evaluations, and get a set of recommendations. In order to access the school building, we need, the XYZ stroller, size 10 instead of size 5. And if there's a disagreement over that, other procedural rights, not the ones I talked about, are available to you, including requesting an independent evaluation. That's if you disagree with the school, or the parents can request a due process hearing when the school denies the adaptive equipment, as I have done on several occasions, to get the school district to pay for a specialized wheelchair for exclusive use within the school building.
Quite often districts will say that they would prefer the parents to go through their insurance provider, but often insurance providers will only, for example, give a new standard or stroller after a 3-year period has expired. But that doesn't mean that children don't have growth spurts within that period of time, and so might grow out of the equipment before that 3-year period is up for renewal. So make sure that you connect and you are persistent with the school to move forward with working to acquire that piece of equipment for the student so they can fully access their education and their curriculum. They have just as much right to access their environment as any other student. And if they need that stroller, for example, in order to do it, it's the school's responsibility to provide it, not you to access it through your insurance. So just make sure you understand that.
We had a question come in about Social Security or SSI, supplemental security, and whether the family needs an attorney. The answer is definitely yes. If the application is denied, you have, I think it's 60 days from the date of the denial letter to request a hearing before an administrative law judge, a Social Security administrative law judge. So applying at the time of application, probably not, most definitely if there's a denial. And there are many denials. There's I don't know if this is still a current statistic, but not too many years ago, there was a 70% reversal rate of initial denials by the administrative law judges. So there is a high error rate, and it's important, just like with special education, parents know their rights, the applicant knows his or her rights, and you present enough information to establish that the applicant meets what's called a listing of impairments. Those are the disabilities that automatically or should automatically qualify you for these benefits. Another question that came in about parents advocating for transition rights. In Connecticut, we start transition planning at age 14 to prepare students for life after high school by focusing on their post-secondary education, employment, and if necessary, independent living skills. And this all starts with a transition, an age-appropriate transition evaluation, not Naviance or something like Naviance, which is available to all high school students, but very specific targeted assessments of the students' interests, preferences, and we then refine those over time because we start at age 14. The age of eligibility ends at the school year the student turns age 22. So there's a lot of information that can be gathered. What a student wants to do after high school at age 14 might differ by the time they reach age 18. So it's important that the evaluations be updated. And this is an evaluation just like all the others. If you disagree, you can get a publicly funded or request a publicly funded independent transition evaluation. And there are 3 or 4 independent evaluators that I make referrals to who complete independent transition evaluations. So it's very important that the student participate in this process because it's their interests and preferences. And there most definitely should be plans after high school. It doesn't have to have a complete roadmap of where we're going to be from point A to point B, but we should have a direction for the student. Are they going to college? Competitive employment.
Just reading some of the questions we've been receiving throughout this evening, and one of them is, what about vision therapy? Districts usually don't share that related service as an option because it's usually contracted. Well, within Connecticut, we do have BESB, which is an organization that specifically has individuals trained to support students with visual impairments and a whole variety of visual impairments. It could be CVI, it could be blindness and various stages of visual impairments. BESB will then work with that student within a school setting and also the practitioners within that environment to make sure that that education is accessible and give support strategies and even some guidance and potential access to different resources to make that environment safe for that student and to allow them to access the curriculum. So BESB is a very good organization within the state of Connecticut to help support students with blindness or a visual impairment. Any other suggestions regarding that, Lawrence or Allie?
I was just going to mention that it is part of the PPT process. In other words, that should be on an IEP as a related service. So BESB or any other visual consultant would be part of the IEP related services as well as accommodation. So you do need to go to a PPT in the state of Connecticut to get that support through BESB or other outside agencies. Right.
We've had a couple of questions both tonight and prior to tonight about 504 plans versus an IEP. It's not that one is better or worse than the other. They serve 2 different purposes. A 504 plan is about accommodations, such as extra time, or we use technology, or we have a need for say a medical need, so we leave the class unobtrusively and go to the school nurse's office for, say, a medication or some medical procedure. There are no goals and objectives. There is no progress monitoring. It's just about accommodations. And for the person who asked whether a 504 plan can follow a student into college, the answer is yes, but it's a different system. You now need to meet with the college office that serves students with disabilities, establish a need for an accommodation in the college setting. So often the colleges will be guided by a 504 plan, but they're not bound by the 504 plan. The IEP, on the other hand, is about direct instruction. And as Allie mentioned, it's about goals and objectives, measurable goals and objectives. If we have a child who has some reading, who struggles with reading or math or fine motor skills or social or behavioral skills that impact their education. We have goals and objectives that are designed to identify the gaps and come up with a plan to help close those gaps over a period of time, typically 1 year. And that's what the difference between an IEP, there are goals and objectives, there's accountability, there's periodic reporting on progress, monthly, biweekly, at least as often as a report card comes out. There's nothing like that in a 504 plan. So it's not like, well, I didn't qualify for an IEP, so by default, I get the 504 plan. It doesn't work that way. They serve two different purposes, and they're both very important, but as I said, they serve two different purposes.
I think it's helpful for families to realize that either if it's a 504 plan or an IEP, all colleges and universities are not the same in their ability to accommodate accommodations. In other words, each college or university has their own set of accommodations that they provide. So just because your child has a 504 plan that may say he or she could use, I don't know, let's just say speech to text, and you would assume that the college or university would accommodate that, that may not be so. So what I also suggest to my families would be to, as part of the transition goals and objectives, to have a goal stating or an objective stating that your child will communicate with the disabilities office within the college or university that he or she is interested in attending, and find out before they are accepted or they even apply what accommodations the college or university provides. Because it's very different than the public school setting, because college and universities really do have their own set of agenda when it comes to accommodations.
The other challenge with accommodations is, as students get older, particularly middle and high school, is that even if they have a 504 with potentially appropriate accommodations, getting the student to access that and use those accommodations can then also become a challenge. I've spoken to numerous parents that are frustrated that their children don't understand the value of their accommodations because it might make them feel different to other students in their classes. So it's important that you help your child understand the value of some of those accommodations, how it can help support them within that class or within that test setting or whatever it might be. And you might need to engage the support of other professionals, whether it's a guidance counselor or a school psychologist or school social worker, to help your child understand the value of those accommodations and to make sure that they use the accommodations that you might have spent time trying to ensure that they have access to. Sometimes as parents, it's hard for our children to listen to us and to understand that we are really there to help. We're not trying to control, we're trying to move them through and help them make progress. So I do understand that can also be a challenge, even if you have them, to get some of the maybe more old and independent students to actually use them and access them to their fullest extent.
We had a question that came in this evening about compliance with the vaccine mandates. And this, again, is Connecticut law. Other states may have different requirements. But all the challenges to the vaccine mandate in Connecticut have favored the state and the local school districts. So unless you can obtain a medical exemption, which has to be completed by a physician, or offer the school through the physician a plan to make up the schedule of vaccines, unfortunately, a school can literally bar a student from registering and attending school. And there have been numerous court challenges, all of them in state or federal court. The state of Connecticut or the local school districts have won on that. So, so if your doctor will fill out a form, saying there's a medical reasons why the vaccines can not be administered, then that will be the case. The problem is a lot of doctors will not fill out that form because there is a quote advisory committee to the Department of Public Health that believe they have the authority to countermand the doctor's professional opinion. So a lot of doctors said, look, I don't need this aggravation. I don't get paid for this. This is my professional opinion. And I'm not going to take on this advisory committee. There might be other doctors that are. So that's very clear. Compliance with the mandate or a schedule to make up, for the missing vaccines. Those are two forms that are available. We no longer have a religious exemption from vaccines, whereas other states still do.
Another question we received tonight, both Florence and Ali, was, can I ask the school to make up speech sessions if I decline services? The school wanted to take the student out of a class rather than a study hall, and I did not agree with it.
So the answer to that would be the IEP, okay? Those decisions are made at the PPT. You may disagree with when the student is taken out. Unfortunately, parents don't necessarily have a choice. You can certainly voice your opinion, but the school really does have the upper hand when it comes to scheduling any related services. If you feel that it is damaging or an obstacle for your child to be taken out, then certainly that's your option, not to have your child go to speech services. But on the other hand, you cannot require the district or the school to provide services at a time that you as a parent feel it's most convenient.
We've had a few questions about students either planning for high school or attending high schools that are much larger. For the planning to go to high school, you can never start too early to understand what your child needs and what's available within the high school setting. So it's very important that parents visit the high school, get a lay of the land, see the school while students are there, not an empty building. What does the hallway look like when the bell rings? What is the cafeteria like? What are the class sizes? How much teacher time is available to the students? If we don't get the teacher time, how do they make up that? Is it all dumped into a resource room? Take a look at the resource room. Is there active instruction going on, or is it sort of a glorified study hall? So there's no one way to prepare for high school. It's just that you know your child, you know how they're going to do in a much larger setting than middle school. So it's important that you get in the building. Now, with all IEPs, with all placements, the placement should be in what's called the least restrictive environment. And the least restrictive environment should be providing a free, appropriate public education. So if the high school is overwhelming because of the size, the noise, visual distraction, sometimes there are alternatives within the district. Sometimes we have smaller high schools. For example, in Stamford, they have the two large high schools, but they have a technology high school that's much smaller called AITE. If that is the way to go, it's small, you're technology oriented, you're staying in district, but you're getting a much smaller setting. School choice or the regional education service centers might, in some of the school choice districts, might have alternatives. So you might have a more specialized high school than the regular high school, and that might be smaller. So it's important that parents understand what options are available to them and their child as they're looking for high schools, because there's not a one size fits all. Some school districts have large high schools, some are much smaller. Some school districts, parents have choices to go to a VOAG school, vocational agricultural school. Some parents opt for the vocational technical high school systems here in Connecticut. And some parents look at their options under, I think it's called school choice.
More recently, I've been working with a number of high school students and families, and the parents were unaware of the variety of classes and choices of classes available to students. Obviously, it depends upon the high school you're looking at, but quite often it's important for you as a parent to, ahead of time, understand there might be different elective options, what those elective options mean, what different tracks your child can pursue, and what different educational environments are available to students within the high school too. So definitely do your research ahead of time so that you can help guide your child to be aware of all the different options available to them. And also through those options, there might be things that they are really interested in and gravitate towards. For example, there might be a forensic science option that might intrigue them, or different computer programming options that might intrigue them, and of different levels and different degrees. Not everything is of a more traditional class, depending upon the district you're in. So start talking to your child about things they might be interested in. When you look at the classes and the electives that might be possible and available, you might want to meet with a guidance counselor ahead of time to get an idea of what these tracks might look like, so that you go into it with understanding and confidence, and then you can help guide your child through that, rather than waiting until they've already joined the high school and then feel overwhelmed by the classes and the options ahead of them. You can start to track it before they even begin joining the high school program.
I think the question about when to transition your child is really student specific. With that, I mean, if you have a very complex learner, maybe a variety of disabilities that require specific planning by the receiving school, the high school, let's say, this is going to require more time and effort and collaboration between the middle school and the high school, compared to a student that may be, I mean, there's no typical LD student, but an average student that has maybe learning disabilities. So if your child is complex in nature, I always recommend a transition plan, and in writing. In other words, the transition plan should be very specific. When activities are going to happen, who's going to facilitate it. There's many different steps in a transition plan. The receiving school needs to collaborate with the sending teachers. The student needs to visit the school. Parents need to visit the school. You need to understand what the curriculum is. There's a whole array of different activities that need to be accomplished. So again, it is child specific, and you know your child, and certainly plan that accordingly. But as Attorney Berliner said, it's probably never too early. So.
And if you have outside practitioners, clinicians working with your child, it's really important that the high school team become familiar with those individuals too, so that you have consistent information being shared. Don't assume that the school district are going to share all that information in a way that is current or that you are comfortable with. Have other practitioners come in if need be to share that with a new high school team, because you don't want things to be lost in translation. You want to be there, make sure that they have access to up-to-date information that is still relevant and describes your child today, because your child today might be different to how they were a few months ago, potentially.
Well, we're getting towards the end of our time this evening. So one last question is really a repeat of what I've said before, and that is, if the parent input and concerns section of an IEP is inaccurate or incomplete, parents need to place in writing those concerns by requesting an amendment to the IEP to include whatever the missing information or the inaccurate information is. And if that request to amend the record of the IEP is denied, you want to ask the school district to place a copy of your letter, your note, your email in the student's educational records. Again, you can't assume. I can't emphasize that enough. You know, parents need to read the IEP, see where it's accurate, inaccurate, understand it, and dispute in writing any portion that's inaccurate or incomplete. And for the person who asked, IEPs updated every year. Yes, at least in Connecticut, we write IEPs for 1 year at a time, 365 days. And that's why many times at the last minute, as that 360th day rolls around, schools realize they will be out of compliance with the State Department of Education. IEPs can be updated anytime in that 12-month period of time. You don't have to wait. I had a parent the other day, I have to wait till April. I said, why? So that's the annual review PPT meeting. I said, this is November. You have concerns today, so why do you have to wait for the annual review? He said, I didn't know I could ask for a meeting earlier than the annual review. So I want to especially thank Allie for, again, joining us. Allie, I've known Allie for many years. That's not to the exclusion of Jane. I've just known Allie much longer than Jane, and both are excellent at what they do. And we're very much appreciate your input. Again, we apologize. We weren't able to get to each and every question, but we got to many. Our next webinar, before I get to that, I hope everybody on the panel and our audience will have a safe holiday season now that we've started with Halloween, Thanksgiving, and whatever happens between now and next year. And that leads us to our next webinar will be on January 9th at 7 p.m. And our special guest will be Carol Frankenberger. For those who logged in October, Carol joined us in October. She'll be joining us again in January with Erica Hocking from Frankenberger and Associates. And they'll be talking about social and emotional learning and its impact upon a student's education and how to involve parents. If you found this evening's webinar informative, please do not hesitate to register in our chat area. One moment. Oh, we will have a link in our chat area. My tech advisor, also known as my daughter, to my right, just told me, but we will have information out there to register for the next webinar. Jane and I will continue to keep a watchful eye on all special education issues and bring to the table whatever we think would be useful for those that participate in our webinars. So I want to thank Allie for participating this evening, and Jane as well for the thoughtful and practical advice and their insights. I also want to thank my daughter, Rachel, who handles all the technical part, the registration, and without her, these webinars would not be put on every month, as Jane and I try to do. We welcome your questions, and I look forward to seeing everybody in the new year. So those are my concluding remarks, and I hope Allie and Jane could add to them.
It's been really lovely to have everybody join us again tonight. I would like to thank Rachel for all her hard work this year, for bringing the webinar series to you all. And I'd also like to thank Debbie, who is Lawrence's wife, who makes all the magic happen along with Rachel. So thank you to both of you. And thank you to all our guests this year. Allie, it's been wonderful sharing this experience with you. We hope to have you back next year. And I'd just like to wish all the families a peaceful and happy holidays. Please, my advice to you is, if you have any concerns or any niggles, don't allow them to manifest. Really start to address those concerns as soon as you can. The earlier we resolve some of these concerns you have, the more progress and more quickly we can hopefully move things forward in a positive direction. So don't hesitate to reach out if you have any concerns, but wishing you all the best and look forward to seeing everybody next year. Allie.
And just a quick ditto on what both you have said. It's my pleasure to be here. I get such joy out of being able to be on the panel, and hopefully all our guests have gained some little bit of information that will become functional and practical for you to use. I wish you all a very happy holiday, a healthy holiday, and we'll see you back at our next webinar. Thank you.
Thank you. Good night. Happy holidays, safe and healthy, and we'll see everybody in the new year.
Bye-bye.